Hi everyone and welcome to Chapter 16, International Criminal Law or ICL. International Criminal Law forms a subcategory of a relatively new and emerging and developing human rights regime. And the novelty of international criminal law primarily lies in the fact that it places responsibility directly on the individual. At the moment, a comprehensive international criminal code does not exist, but the International Law Commission has produced a bunch of agreements on 5 international crimes: aggression, genocide, war crimes, crimes against humanity, and crimes against UN personnel. So these are 5 categories of crimes that fall under the purview, under the definition of ICL, and the universal jurisdiction applies to them. So countries have the option to either try or extradite perpetrators of these 5 categories of crimes. There are a bunch of other crimes that could potentially fall under international criminal law, and they include terrorism, piracy, torture, air hijacking, hostage taking, and slave trade. In this chapter, we're going to be dealing primarily with genocide, war crimes, and crimes against humanity, and we'll be covering aggression in subsequent chapters. So, crimes against humanity. Before we go there, actually, I want to make a distinction and a differentiation between genocide, crimes against humanity, and war crimes. So there's overlap between crimes against humanity, genocide, and war crimes. However, we can distinguish crimes against humanity from genocide in that crimes against humanity and war crimes do not require an intent. Remember, the notion of intent is a key term here. So crimes against humanity and war crimes, as opposed to genocide, do not require an intent to destroy a group of people in whole or in part, while genocide does. Also, the difference between crimes against humanity and war crimes is that crimes against humanity apply in both wartime and peacetime. Now, the definition of crimes against humanity has evolved over time, but the London Charter of the International Military Tribunal defines them as murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds, and execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country were perpetrated. Then you have a bunch of additions to this definition. For example, the International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR, they add rape and torture to that definition. Then the International Criminal Court, ICC, adds enforced disappearance of persons and apartheid. And like I said, remember the difference between crimes against humanity and genocide, and crimes against humanity and war crimes. So the Rome Statute and the International Criminal Court that emerged out of it define crimes against humanity as follows. So it goes, for the purposes of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. Again, the notion of intent is key here. And the acts that fall under this definition include murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. It also includes persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender, as defined in paragraph 3, or other grounds that are universally recognized as impermissible under international law in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. Crimes against humanity, according to the Rome Statute, also include enforced disappearance of persons, the crime of apartheid, and finally, other inhumane acts of a similar character intentionally causing great suffering or serious injury to body or to mental or physical health. So as you can see, this is a very broad-based and comprehensive definition of crimes against humanity. This slide includes a couple of examples of crimes against humanity trials which occurs after World War II. So we have obviously the Nuremberg trials, the Tokyo trials, the International Criminal Tribunal for Yugoslavia, the ICTY, the International Criminal Tribunal for Rwanda, the ICTR, the International Criminal Tribunal for Sierra Leone, and finally the International Criminal Court, the ICC. So next is genocide, which in international law has been also defined as the international crime among crimes. According to the Genocide Convention of 1948, genocide is defined as any of the following acts committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group. And some of the examples of genocide are killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. So also including genocidal crimes include apart from genocide itself are conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. So essentially all these 4 acts also according to the Genocide Convention of 1948, they also qualify as genocidal crimes. Now, actual examples of trials under the Genocide Convention of 1948, the most important and the most well-known example is the International Criminal Tribunal for Rwanda, the ICTR, where Jean Paul Akayesu, the former Burgmaster of Taba. Burgmaster means mayor in French, so he was the former mayor of Taba, a city in Rwanda. Became the first individual convicted of genocide by the ICTR in 1998. And then you had Jean Kambanda, the former prime minister of Rwanda, who became the first head of government found guilty of a genocidal crime. The second attempt in international law to try individuals for genocide occurred during the International Criminal Tribunal for the former Yugoslavia, but nothing really came out of it because Serbia was cleared of charge of genocide, because the threshold to meet the definition of genocide is it's a pretty high bar. So Serbia didn't clear that bar according to the ICTY. On the slave trade, you have the Slave Trade Act of 1804, which abolishes the slave trade in the British Empire, but not slavery per se. In the United States, you have Article 1, Section 9 of the United States Constitution, which protected the slave trade until 1808, but then the 1820 piracy law was enacted, where federal statute against piracy was amended and declared participation in the slave trade to be piracy as well. So technically, slavery was lumped together with piracy. Next, you have the Convention of Saint-Germain of 1919, where the signatories affirmed their intention of securing the complete suppression of slavery in all its forms and of the slave trade by land and sea. And finally, you had the 1926 Slavery Convention that was created under the auspices of the League of Nations, where the parties agreed to prevent and suppress the slave trade and to progressively bring about the complete elimination of slavery in all its forms. So remember that the notion of piracy has gone through quite an evolution from an act that used to be even romanticized to a completely illegal act. But the most important effort to codify illegality of piracy according to international law happens during the UNCLOS 3 Convention, where Article 101 defines piracy as consisting of the following acts. A. Any illegal acts of violence or detention or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft, and directed on the high seas against another ship or aircraft or against persons or property on board such ship or aircraft, against a ship, aircraft, persons, or property in a place outside the jurisdiction of any state, and B, any act of voluntary participation in the operation of a ship or of an aircraft with knowledge of facts making it a pirate ship or aircraft. So again, as you can see, this is a quite comprehensive and broad definition of piracy. Then you have Article 102 of UNCLOS 3, according to which piracy by a warship, government ship, or government aircraft whose crews has mutinated, also qualifies as an act of piracy as defined in Article 101, committed by a warship, government ship, or government aircraft whose crew has mutinied and taken control of the ship or aircraft. And so these acts are assimilated essentially to acts committed by a private ship or aircraft. So this distinction between private vessels and government vessels or warships are essentially they're essentially that distinction completely gets eliminated according to UNCLOS 3 definition of piracy. But remember that maybe the only limitation in this definition is that it confines piracy to the high seas. There's a technical note here that I would like to make, and that deals with the question of piracy and piracy regime in the exclusive economic zone that we've covered when we talked about the law of the seas. So the exclusive economic zone piracy regime states that the regime of the high seas applies within the exclusive economic zone, the EEZ, to the extent that it does not impinge on the right of the coastal state to enact measures for conservation of the living resources. So that's the only limitation that essentially curtails the application of the piracy regime according to UNCLOS 3 in the exclusive economic zone. Now, Article 105 of UNCLOS 3 states that on the high seas or in any other place outside the jurisdiction of any state, every state may seize a pirate ship or aircraft. So as you can see again, the notion of universal jurisdiction applies here. Article 107 reads that ships and aircraft which are entitled to seize on account of piracy, and a seize on account of piracy may be carried out only by warships or military aircraft or other ships or aircraft clearly marked and identifiable as being on government service and authorized to that effect. So the authority to impose the previous articles only belongs to warships or military aircraft or other ships that have governmental authority to discharge those duties. So this is not just an arbitrary thing that any vessel could do. So Somalia is obviously one of the prime examples where the issue of piracy has been quite prevalent recently. And to deal with the problem of piracy off the coast of Somalia, in June 2008, the UN Security Council passed a declaration that authorized nations that have the consent of the transitional federal government in Somalia to enter Somali territorial waters to deal with pirates. And the jurisdiction here, again, because of the universality of jurisdiction in dealing with piracy, the jurisdiction consists of either try, extradite, and obviously capture. Another well-known example of the application of the anti-piracy regime was the Italian Achille Lauro cruise ship, which was hijacked off the coast of Egypt by the Palestinian Liberation Front, the PLF, where the U.S. Tomcat intercepted and forced landing at a NATO base in Sicily in Italy, but eventually the the PLF folks were released on insufficient evidence for extradition. Next, you have hostage taking as an international crime during peacetime. The international legal regime dealing with hostage taking during peacetime is the so-called Hostage Convention of 1979. And Article 1 of the convention reads, any person who seizes or detains and threatens to kill or to injure or to continue to detain any other person in order to compel a third party, namely a state, an international intergovernmental organization, a natural or juridical person, or a group of persons to do or abstain from doing any act as an explicit or implicit condition for the release of the hostage, commits the offense of taking of hostages or hostage taking within the meaning of this convention. Also, the definition of hostage taking extends to any person who, one, attempts to commit an act of hostage taking, or two, participates as an accomplice of anyone who commits or attempts to commit an act of hostage taking, likewise commits an offense for the purposes of this convention. All right, next slide deals with the international crime of torture. Again, the international legal mechanism dealing with the question of torture is the Convention Against Torture, CAT, of 1984, where Article 1 reads, any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or of any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. This definition excludes pain or suffering arising only from inherent or incidental to lawful sanctions. Now, in U.S. criminal law system, the application of these international crimes has a very interesting trajectory and history. So first you have this Alien Tort Statute of 1789, which seems to suggest universal subject matter jurisdiction on these most egregious crimes. And the ATS, the Alien Tort Statute, reads, the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. There are a couple of examples and cases that deal with this Alien Tort Statute. One of the interesting ones was Flartiga versus Panerola of 1980, where the U.S. Court of Appeals for the Second Circuit claims that the Universal Declaration of Human Rights manifested an expectation of adherence to the prohibition of official torture, and two, the right to be free from torture is a principle of customary international law. But contrast that Flertiga versus Pena Urala case of 1980, where the Alien Tort Statute is upheld with two other cases. The Sabatino case, where the act of state doctrine was upheld, and also with Sosa v. Alvarez Machan case, where I'm gonna give you a brief summary of how the Supreme Court decided. But before going there, I just want you to know that the Alien Tort Statute essentially permits an alien to file a tort claim against any person over whom the United States has jurisdiction, regardless of whether the defendant is a U.S. citizen or a foreign national, and regardless of whether the alleged tort took place within or outside the territory of the United States. So in Sosa versus Alvarez Machan case of 2004, on the ATS claim, the United States Supreme Court ruled that the Alien Tort Statute did not create a separate ground of suit for violations of the law of nations. And this, as you can see, contrasts with the ruling of the U.S. Court of Appeals for the Second Circuit in the Flertiga case of 1980. In the Sabatino case of 1964, the U.S. Supreme Court determined that the policy of the United States federal courts was to honor the act of state doctrine. This is very interesting because in this Sabatino case, the Alien Tort Statute actually comes into conflict with the act of state doctrine. But the Supreme Court decides that it was the policy of the United States to honor the act of state doctrine, which essentially dictates that the propriety of decisions of other countries relating to their internal affairs would not and could not be questioned in United States courts. Another interesting example of the application and jurisdiction and universal jurisdiction of the crime of torture was the Augusto Pinochet case, the dictator of Chile, and his indictment and arrest in the United Kingdom, where you have a conflict between state immunity or sovereign immunity and flagrant violations of international human rights law. So here, the United Kingdom puts Pinochet under house arrest because an international arrest warrant is issued by a Spanish judge against Pinochet on the alleged crime of torture of Spanish citizens between 1973 and 1983. So Pinochet alleges head of state or sovereign immunity. The British House of Lords then decides that Pinochet could only be prosecuted for crimes committed after 1988, and this is the date when the United Kingdom essentially starts implementing the Convention Against Torture, and where this notion of extraterritorial and universal jurisdiction would apply to the crime of torture. So what the House of Lords does, in essence, is that it invalidates the majority of charges against Pinochet. And then the Home Secretary Jack Straw rules in 2000 that that Pinochet should not be extradited to Spain on ill health grounds. And finally, Pinochet is allowed to return to Chile in March 2003. But the significance of this case is the unprecedented detention of a head of state, Augusto Pinochet, in a foreign country for crimes against humanity committed in his own country without a warrant or request for extradition from his own country. And this is, as I've mentioned here, this is a watershed event in international law and in the evolution of international criminal law. And this case of Pinochet essentially demonstrates that these crimes are so egregious that they constitute crimes against humanity and can be prosecuted in any country, in any court in the world. Hence, the notion of universal jurisdiction. All right.